If you belong to an exempted establishment and your pension application for higher pension has been denied, this video is for you. Are you an employee from an exempted establishment whose higher pension application was rejected by EPFO? In this video, we break down why that might have happened and help you understand the legal and procedural details involved. To understand the rejection, we need to look at the connection between EPF contributions and pension eligibility, especially how the law treats exempted establishments. A member of Employees' Provident Fund can contribute above wage ceiling under sub-para 6 of para 26 of EPF scheme, which reads, notwithstanding anything contained in this paragraph, an officer not below the rank of an Assistant Provident Fund Commissioner may, on the joint request in writing, of any employee of a factory or other establishment to which this scheme applies and his employer, enroll such employee as a member or allow him to contribute more than rupees 15,000 rupees of his pay per month if he is already a member of the fund, and thereupon such employee shall be entitled to the benefits and shall be subject to the conditions of the fund, provided that the employer gives an undertaking in writing that he shall pay the administrative charges payable and shall comply with all statutory provisions in respect of such employee. In case of employees of the exempted establishment, the approved trust rules replace the EPF scheme. In such case, contribution by employee-employer on higher wages is governed by provisions of approved trust rules applicable on exempted establishment. Thus, there must be enabling provisions in the trust rules to allow such higher contributions. For employees of exempted establishments, contributing to the pension fund on higher wages depends entirely on whether their EPF trust rules support it. The pension is only possible if the EPF contributions were also made on higher wages. Any contribution in pension fund for calculation of pension under EPS 1995 is follow-up of contributions under EPF. Thus, enabling provision to contribute on higher wages and possible diversion to pension fund is sine qua non for pension on higher wages. Paragraph 11(4) of the EPS 1995 only defines how the pension is calculated using the higher salary, but the actual contribution must already exist. If the contributions weren't made, this clause alone doesn't help. The government clarified in Parliament that contribution on higher wages was a conscious choice, one made jointly by the employee and employer before the 2014 amendment. If the EPF trust rules didn't allow that, the employee effectively opted out. Trust rules are manifestation of option exercised towards higher pension contribution by employer and employees of an exempted establishment. Every exempted trust operates under rules formed with agreement between employers and employees. If the trust didn't allow higher wage diversion to EPS, EPFO sees it as the members' prior decision to prioritize EPF over pension. In short, your eligibility for a higher pension doesn't just depend on your salary, it depends on what your EPF trust rules allowed. If they didn't permit higher contributions to EPS, your application was likely rejected for that reason. EPFO has rejected the applications based on this interpretation that trust rules are manifestation of option exercised towards higher pension contribution by employer and employees of an exempted establishment. If you have any queries, please comment below. Thanks for watching. Don't forget to like, share, and subscribe if this helped you. Stay informed and empowered.